This is an age of disruption, of profound revolutionary change.
What we're really asking ministers is to empower the ambassadors.
The only thing that you really push forth is the truth.
You don't see many women represented when it comes to the decisions as to how to handle the pandemic.
Hello, everyone. I'm Christy Goujar. I'm a tech reporter with POLITICO, and we're here today for a panel on the DSA, the new EU's content moderation law that will soon come into force. And with us today, we have a great panel of other great women with me. We have Rebecca Trumbull, Director for the Institute of Data, Democracy and Politics. Thanks for being here with us today, Rebecca. We have Rita Wezenbeck, Director of Platforms at DG Connect for the European Commission, obviously. Helen Dixon, the Irish Data Protection Commissioner, straight from Dublin. Thanks, Helen, for coming. And last but not least, Siadal Ramley here in Brussels, Director General of .Europe Tech Association. Please sit down. So a few reminder with some housekeeping rules for this Politico Tech Summit. You can ask questions only through the Swapcard platform. The instructions you can find on our event website. If you're on the platform already, you can feel free to chat with fellow attendees and ask questions in the questions box to the right of the screen if you're on a desktop, or below the live stream if you're viewing on your mobile. Okay, but now let's kick off. We have a great guest and a short time for our great panel, so let's get started. So I'm looking at you, Rita, yes. Because just this week we've had the designation of 19 very large online platforms and search engines. So the text is going really, really fast. It was adopted last year, now designation in 4 months. They need to be ready to comply, and the Commission will be able to investigate potential infringements on a broad number of rules, from a ban on targeted ads for minors to risk assessment on fundamental rights and societal risk. Yep. This will come August 25?
End of August.
End of August.
Yeah, there's very complex mechanism of calculating days in the Commission.
Oh, what does sorry, what does that mean? Because Thierry Breton, the EU Internal Market Commissioner, said August 25.
If the Commissioner said so, then it's correct.
When do you expect to get to be ready for the Commission?
I would say end of August. Yes, of course, we're ready. We're ready now. But the platforms should have their risk assessment finalized by the end of August.
Okay. Yep. But and how ready are you, the Commission? We have these big platforms. They will be coming with a risk assessment, ready to comply. Will you be ready to enforce the rules?
Well, we were already ready to adopt the decisions, and we are also already in discussions with the platforms for quite a long time. So they know more or less what we expect. We are at the same time building up our teams, so we are still recruiting and we are growing and growing. And we are getting all our, let's say, facilities in place that we need. We need a registry, we need the IT in place. We need a database, so all of that is being prepared. We're also working intensely with the member states to have the digital services coordinators appointed. So indeed, we are ready. We're also setting up, and you saw there was the opening of the ECAT, or the inauguration of the ECAT last week. So there we have our tech colleagues who are ready to analyze algorithms and the IT elements of the platforms. We're reaching out to others with whom we can cooperate. We're reaching out to civil society, researchers, with whom we can cooperate to have an appropriate and effective implementation. So yes, we're ready to apply, to enforce, and we're also still growing into setting up the right corporations. Yeah.
Siada, your association represents some of these very large online platforms, from Facebook to TikTok. they have 4 months to comply. Is that enough time for them? What are they telling you? Will they be ready?
Well, some of the ones that we work with obviously did see it coming. It wasn't a surprise, so they have been preparing, and they are going to do their utmost. They have to comply. So they're all in a position where they have indeed been discussing things with the Commission, been very open, and also talking about progress and what the next steps are. So I think it's going to be a collaborative effort. I do think, though, there's a different way of doing normal compliance. There's a lot more to it. And so this dialogue is going to be key in how it takes shape going forward, because the Commission will have to be abreast of what is actually being done, whether there are real steps being made, that it by no means, and there is no intention for it to be window dressing, but to keep them abreast of what's actually happening. So I think that collaboration is going to be key to how things work out, indeed.
Helen, you've been the lead regulator of big tech companies for the last 5 years under the GDPR and this one-stop shop mechanism. You faced some criticism about sort of enforcing the GDPR on these big companies. What did you wish you'd known when you started enforcing the GDPR in 2018? What kind of advice would you give to the Commission?
Well, in some ways, you can't look back and know what we've since learned over the last 5 years. Rita and I were having some interesting discussions before we came on stage today. And while you have to make detailed preparations, and everything Rita said sounds so familiar to me, preparing IT systems, preparing processes for engagement with regulated entities and so on, in some ways, with laws this novel and complex, where they're world-leading in terms of what they're attempting to do in regulating content, in regulating disinformation and so on, there is an element of suck it and see, including around the cooperation aspects, as well as figuring out incrementally the procedural aspects. It's, of course, critically important for legal certainty and for the regulated entities, and in terms of results that we're all seeking to deliver, that processes are as nailed down as possible. But, you know, we already see in terms of lessons learnt over the last 5 years from the GDPR that now the EU Commission is looking at a limited administrative harmonisation law around the cooperation that's prescribed in the GDPR, because there simply was a realisation that when administrative laws across the EU are not harmonised for good reason, but you then try to have forms of enforcement that are harmonised across the EU, that there are going to be gaps. So I think the lessons learnt are that everyone has to commit fully to the process, but some things will only fall out once you begin.
Rebecca, what are your expectations for come September? What sort of investigations do you want, or enforcement actions do you want to see the Commission taking to hold these platforms accountable to some basic content moderation rules that have been lacking in the last years?
So I think realistically, I think our expectations come September need to be, in fact, realistic. I particularly appreciate the way that the Commission is thinking through and putting in place the mechanisms for algorithmic transparency, to better understand sort of the fundamentals of the way the platforms operate. But I do worry, as I've been hearing larger members of a variety of communities talking about what to expect come September, that there's a focus on sort of individual actions, that there's an expectation that the Commission or digital services coordinators in the months to come will be focused on, did Facebook do this one thing exactly right? Or did Instagram or TikTok make a mistake here or there? And I think the appropriate way for us to be thinking about the investigation and enforcement of the Digital Services Act is at a systemic level. And that if we start with that approach to understanding how the DSA canon should be enforced, that then we're looking at very different types of questions that we should be asking, rather than, in this one instance, did they get it right or wrong?
What do you think, Rita, of Rebecca's?
Yes, I very much agree with that. I mean, it would be a misunderstanding if there's an expectation that the Commission will have 5,000 fact-checkers working for itself, or that the digital services coordinators would have that. So the principle of the DSA is that it's a very balanced act. We maintain the principle that the platforms are not liable for the content that appears on their screens. They're also not expected to monitor every content that is published. However, they need to have due diligence procedures in place, which means having the terms of reference published. So tell the outside world what they do in terms of content moderation. They have to have complaint handling procedures. They have to have dispute resolution. They have to have actions if there's unlawful content. And they have a lot of transparency and reporting obligations, which means that they install some kind of decency and also legal certainty on their platforms. So this is the way that it works, and it's not, as of September, we will all sit there and check what is appearing on Facebook. That will not happen.
Okay. Sierra, can you tell us a bit more? Because part of the requirements for the very large online platforms is these very broad risk assessments and mitigation for systemic risks. And they're very broadly laid out in the DSA, but sometimes it's a bit unclear what will be what specifically would be audited or requested. So are your members asking you, how are they preparing for that?
So there are obviously questions about how it will actually be translated concretely, but at the same time, I think we need to go back to what the Commission intended with this piece. And there was a vision there to create a framework rather than to go very prescriptive into the nitty-gritty, but to create something that will be able to last the test of time, and to create an approach to how to tackle content moderation. And I think that is the right way forward. We're seeing already some developments outside of the DSA that might potentially undermine it, and I hope that doesn't happen. But I think
Sorry, can you be more specific?
Yes, of course. So, for example, the EMFA, some of the developments in the European Parliament.
The European Media Freedom Act,
EMFA. Yes, sorry. The acronyms. Brussels and acronyms, sorry. But indeed, the European Media Freedom Act, where we see some of the developments almost trying to supersede the core principles that the DSA is setting out. And I think it would be a shame if we lose this framework approach to have a holistic way to tackle, indeed, the responsibility, the accountability, which is almost, well, it definitely is more valuable than just looking at one particular instance. But the companies need to understand what is expected of them. And that goes back to my first point about the dialogue, where the Commission has been very open to have these discussions. So continuing this discussion, and we see also as an association that we would like to try and help in that, facilitate that kind of discussion, just to understand what is expected indeed.
Rita, do you share Sierra's opinion that there's too many laws, or do you say it's not even being enforced, that there's so many laws already on the table that are trying to regulate more? European Media Freedom Act, child sexual abuse material, everything's out there already.
I'm not sure this is exactly what she said, but and also I would not want to go into the negotiations that currently take place. But I mean, what is really important to realize is that with the DSA, we now have an overarching framework that applies throughout the European Union, so which is good for the platforms and for society as a whole. They know what to expect. And this framework is intended and is capable of realizing the goals that are right now also being debated in more specific legislation. So on the basis of this framework, with perhaps specific rules for specific situations like lex specialis, but the framework is able to reach what are the objectives also in individual situations.
Rebecca, Rita was mentioning earlier how necessary researchers will be to help enforce the DSA and also to look at the systemic risk and algorithms and so on. How crucial will researchers be, and what kind of access do you need to have to fully understand how these platforms work?
Well, one thing that I really appreciate about the DSA is that it takes seriously the need for having independent external researchers, whether that's from academia, civil society, and beyond, integrated into the work of essentially platform assessment and accountability. It's actually quite almost profound for me to be sitting here today today on this stage, because the last time that I was in this room sitting on this stage was 3 years ago, basically 2 or 3 days before we had the worldwide shutdown of travel, and we were sitting in this room talking about the need for researcher access to support, right, evaluation and accountability for the platforms. And so now, almost to the day 3 years later, we have this in place. And it feels incredibly powerful, but of course, the irony now is that we have to do it. It means that we need, for example, the Commission is working as we speak on writing a delegated act for Article 40, which is the main provision that allows for independent researcher access. And until we have that, right, it's always the devil in the details. Until we have that, we won't know in practice what this looks like. But the Commission is doing a great job of consulting with researchers very broadly to get their input on how this should take shape. The core challenge I see now is that we have across Europe a very diffuse sort of community of these researchers, and we now really need to be working together to do some coordination and planning to make sure that we're empowered, that we're bringing to the Commission the sorts of information that they need. And I mean, to put it quite bluntly, academics and to some extent civil society researchers aren't very good at coordinating ourselves. And so this is what I see as probably the largest challenge in the next 12 months or so.
Yeah, so maybe to add to what Rebecca says, I mean, I subscribe to what she says. It's a challenging world, but also with a lot of promise, in the sense that there will be much less asymmetry of information between enforcers, helped by researchers, and platforms. So there will be much more possibility to analyze what is really happening. But this being said, it's maybe good to note that we have also, on the same day as we adopted the decisions, we have published what is called a call for evidence. That is quite a small document that actually asks for input and for reactions, and asks a lot of questions to the wider community of researchers, but also the platforms, on how would you see this working. So how do we do the vetting? I mean, how do we assess conflicts of interest or commercial interests that might influence researchers? I mean, do we need something like a peer review, for instance, between researchers? So we're looking at that. This will be a short consultation, and then probably somewhere at the end of the year we would come with a proposal for a delegated act. Again, call for reactions, and then make sure that it is ready to be enforced once the digital services coordinators are ready to vet.
Helen, what has been sort of the help from researchers to help enforce the GDPR? Have you relied on their expertise?
To some extent, but actually, even in the 5 years of the GDPR, there's been very little empirical research on the perceptions of individuals towards their rights and the GDPR. And the limited research there's been a good study in the Netherlands called Data Protection or Data Frustration. That limited study in the Netherlands showed very high levels of reactance to the GDPR from individuals, and a feeling that they weren't reaping the benefits in their personal life, that the GDPR was a nuisance and overly clamping down on community-based and sporting activities. Publishing photos of club teams became prohibited, and in their workplace then a burden where they lived in fear of making a mistake. So actually there's a need for much more research. It's interesting to hear Rita talking about the researchers getting access to the logic of algorithms and so on. GDPR is obviously different. It's an area of regulation of fundamental rights as well, and there's very limited empirical research. So we follow and look at what's there, but I think there needs to be more. And maybe if I could just come back on something that you've been having an interesting discussion on, it is that question of individuals and their experience as users on platforms. Clearly, I agree with everything the panelists say. The aim of the DSA is correctly to start taking incremental steps in content regulation where this is looked at systemically. It seems to be the only way to go. But I think there is a question mark in terms of the DSA around how individuals who are users of the platform experience ongoing issues with content despite the systemic regulation. And there are complaint lodging mechanisms with digital services coordinators under the DSA. There are ways for DSCs to refer issues onto the Commission and so on. But what will that level of interaction between the public enforcement authorities and individuals be in reality? Will it meet their expectations, I suppose, is what I'm saying.
Yeah. Rita, I think, yeah, it's true that in a crowd like us, we speak about systemic risk and algorithms and everything, but a lot of people are just seeing how chaotic Twitter has become, or how a teenage girl has seen too many photos of diets on her TikTok or Instagrams or things like this, or at least that's what they're seeing. So, you know, do you think you'll manage? Are you worried sometimes that you'll struggle to meet their expectations of what the DSA is supposed to achieve?
We need to take things step by step. So designation first, and now we will see the risk assessment, and then we will see the external audit. So we will look at all those things, because we cannot exclude that the platforms are willing to engage and to comply. So this is the first step. If we then have signs that there's no compliance, or there's like a civil society saying, look, they say one thing, but we observe the then it's time for a good dialogue. And then we can take action. So indeed, you know, if there's a wide discrepancy to what is observed and what is stated, this would be ground for us to intervene.
But do you think you'll struggle to answer their expectations, these very people at the bottom who don't understand this whole process of dialogue, and who think you'll just crack down on a platform for one very specific thing?
Yeah, it is all case by case. It depends very much. So you may have also many people who may complain about relatively petty issues. And so then we should not be expecting of the Commission to intervene for every individual who says, well, I don't like the way I'm portrayed, or I don't like what the neighbor says about me. If it becomes a systemic issue, and in particular the virality of platforms is an issue there. So if information is amplified and it gets a lot of indignation, uproar, problems in society, then even an individual issue could be an issue for the Commission to look at.
Rebecca, you wanted to comment?
Yeah, so I think one of the challenges leading up to the DSA has simply been that the way that people understand the way that the platforms operate is through their individual experience and through reporting, right, journalistic reporting, which tends to be anecdotal, tends to be incredibly powerful, but is anecdotal. I think the power of the potential power of the DSA is that it allows society as a whole to get a better, bigger picture understanding of what the problems are, where the risks lie, and how it's harming us writ large. And so I would hope at least, but expect to some extent that some more of the stories that your average user is going to be hearing will be at these higher systemic levels. And so it at least gives them another point of entry for understanding what the problems are, rather than just their own personal experience, which of course will continue to be powerful. But if the DSA operates properly, I think there's a lot more reporting that happens from this bigger picture perspective.
Yeah, and I think if we only try to focus on the individual cases, we will never meet expectations, to be very frank, because I think there are so many different kinds of individual cases that we probably won't. But tackling the systemic risk is the way to go about it, so that you've got the process in place, that you've got the mechanism functional to actually at least capture most of the issues. And I think that that's where we're going first. And hopefully we can turn the narrative from it being a few years ago, there was kind of a common perception that this is an unregulated space, rightly or wrongly so, I'll still say that, but to this is being dealt with. And I think that that's where we will kind of also be relying on everybody involved, be it civil society, be it the Commission, be it the platforms, communicating about what's being done and how it's being tackled, because we will need to aim at changing that narrative more broadly and creating an understanding of what's being done.
Yeah. There may be one thing indeed to add. So if you say, you know, what will this 14-year-old girl who sees all these beauty advices that may be harmful to her health now perceive? I mean, there should be quick complaint handling procedures. So first, the platforms need to be clear on what is their policy with respect to those things. They need to have a quick complaint handling procedure. They need to state their reasons why they may not do what is asked or why they may do what is asked. If they do what is asked, they need to explain to the one who has put the content. So there is a process now, and these girls and their parents and everybody in society should know the world has changed after the designation. So the platforms need to have those procedures in place. They need to be public on what they do, and they can be held accountable by everybody in society.
We've seen in the enforcement of the other European big tech law, the GDPR, that sometimes there are disagreements between the different national regulators in the way they interpret the law. Do you expect such disagreements between the Commission and the digital services coordinators in different countries?
So the system is that every complainant can file a complaint with his own digital services coordinator, but the one who handles it is the digital services coordinator of the country of origin or the country of, let's say, establishment of the non-European platform. Then this is what the digital services coordinator of that country will look at. It will probably take into account, if the complaint comes from another country, how it is perceived, how this would be perceived at a European level. And if there are real issues of wide discrepancies, we have the Digital Services Board, which is the board of all the digital services coordinators who can look at those issues. But in principle, the philosophy is we live in Europe, and this is an internal market, and the digital services coordinator of the country of origin should look at this through this European lens.
Rebecca, the digital services coordinator is the one in charge of designating the researchers with access to the data. However, they will only be designated by February 2024.
Right.
What do you do in the meantime?
In the meantime, we prepare a lot. In the meantime, we have lots of discussions amongst ourselves as the research community, also with the Commission, as we learn more about who the digital services coordinators will be, even if they're not officially designated. During this period, we spend a lot of time figuring out what are the most pressing needs, what are the most important research questions, how do we prioritize the sorts of data requests that we will be making. It's really important, and I think having talked to so many members of the researcher community just in the last few weeks, that people really fundamentally understand that for all of this to function properly, we can't run at all of the DSCs with hundreds of different requests that essentially overwhelm the system. And so I think in roughly the next year or so, we'll be focused on how do we properly organize that, what are the priorities among researchers, and how do we go with reasoned and reasonable requests to the DSCs once we have the opportunity to do so.
Helen, as part of the European Data Protection Board, you've seen these disagreements with other data protection authorities. How do you manage to reconcile these views? What sort of advice would you give to Rita as to sort of reconciling the interpretation of one single European law?
Yeah, I mean, I was interested when you mentioned disagreements between European data protection authorities. And of course, the GDPR and its one-stop shop is very particular and very different to the type of coordination envisaged under the DSA. And so actually the GDPR provides for the ability to create disputes. It allows other data protection authorities lodge objections to drafts of my decisions and then sets up a mechanism to resolve those disputes. So I just want to make the point it's an intended part of the process. It's how we come to one view. It's different. It's not a co-decision-making process. As Rita said, under the DSA, it is much more pure country of origin. The coordinator in the country of establishment, which will be Ireland in many cases, in relation to some of the platforms, will act. What I would say, to come to your question in terms of advice, is that as you said earlier, the Irish Data Protection Commission is the lead supervisory authority in respect of a lot of the systemic and big issues in data protection. One of the things that we learnt is that we should have situated permanent staff earlier out in Brussels. My office is now putting staff that are going to be permanently based out here so that they're more agile in terms of being able to meet key stakeholders in the Commission, the Parliament, and around Brussels. And so I think the advice is there has to be very close coordination. The authority in the country of establishment that's leading on matters needs to acknowledge the pan-European nature of the role they're playing and not underestimate the strength of feeling they will find, particularly around content issues in other EU member states, and respect that. It's going to be challenging, I would say, based on the experience of my office to date.
Sierra, do you agree with Helen's assessment that it will be challenging?
Potentially, but I also agree very much that it's important to get the resourcing right from the get-go. And I think that if there's one lesson learned from the GDPR experience is that we only learnt about some of the cracks that we faced as a community more broadly as it came into force, because it was at the time it was revolutionary in terms of approach. The one-stop shop was something completely new. And I think that hindsight's always great to look back at things, but taking the experience of the GDPR, getting the resourcing right and the expertise right from the get-go is going to smooth things over a lot. There might be areas where there will be some form of disagreement, but I think that the mechanism is different than the one-stop shop of the GDPR that actually created that dispute to come to a conclusion. So,
You mentioned areas where there could be disagreements. Do you have any areas in mind?
I don't have ones that I'm going to or that I necessarily have identified. Let me put it that way. Not that I'll name, but that I have identified. But there could be. You never know.
Rita, do you have ideas of areas where there could be disagreement?
That's too early. Let's take things step by step. But I think there's some things I would like to signal also in the comparison between the two systems. I mean, I think for the DSA, it is really important that for the very large online platforms, it's the Commission who is in charge. So for the whole of Europe, it's the Commission who looks at enforcement and compliance. So that's one thing that is different from having a system where one of the member states looks at this and looks also at the interests of the potential interests of the other member states. That's one thing. And another, I think, really crucial difference is that these will be regulated entities. So in certain aspects, the comparison is much easier with the systemic banks who are under the supervision of the ECB. So this will be a continuous relationship with a lot of reporting, with a lot of dialogue. And so this will not be something where we go case by case. It's from now on, we are partners with the platforms and we listen to what they say and we count on them listening to what we say. So that's I think a crucial difference. So if you then go for below the very large on platforms, there are more similarities. There's indeed the digital services coordinator of the country of origin, and there I fully agree with also the need for appropriate staffing, independence, funding. So I mean, there I think all the advice that you give is very wise and well taken into account. Yeah.
Just to say, I think one of the areas where we are going to see some of that challenging disagreement or shakeout is around children. We see that already in terms of very different views in the member states, and indeed the GDPR gave discretion to member states around setting ages for consent under GDPR. There are very different views around hard age verification and whether systems should exist and so on. So I think children is always going to be an area where you see some level of contention. Just in relation to that matter of the VLOPs and the Commission being the regulator, it's of course got exclusive competence for those Section 5 Part 3 issues under the DSA, but where the Commission doesn't initiate proceedings, then it does fall back to the national country of origin coordinators. So I think some of the VLOP enforcement will indeed be done by those national.
Yeah.
Thank you. I think we've come to our time. It was quite fast, but thanks for participating and being here today. Thanks to the audience here in this lovely hotel and also online. You can stay seated or stay online, and we will soon have an interview with the European Data Protection Supervisor Wojtek Wiewiorski. So thank you for being here, and see you for the next session.